Thanks everyone for the welcome and Bill for the kind words. It's certainly been a pleasure getting to know Bill and everyone from RCAF in the last 4 years. And I'm very glad to say I no longer need the cattle for dummies. Probably cattle for the slightly backward would get me there just now. But it's been a real pleasure working on the matter. I'm really glad to get out here again and speak with you all and catch up with some good friends. As Bill said, I'm going to try and give a quick update. Sorry, I thought someone was speaking to me. Quick update on the litigation, a reminder what you can all do, a quick update on where the parallel government investigations are. I'm sure, as you all know, the DOJ, the state AGs, and the USDA is investigating some of the same things that we are prosecuting in our case. And just a few thoughts on some other relevant ag litigation that's going on. So the biggest case development since we spoke last year is that soon after we spoke in September last year, the court denied defendants' motion to dismiss. This is the defendants' their first big attempt to kind of kick the case to the curb. But the judge rejected that in a really great ruling for us. He sort of upheld the validity of all of our complaint, all sort of 200 pages of it. And the real gravamen of the complaint was that we had pled enough facts to plausibly suggest that they were conspiring to push down the price of cattle. So what that means is the case is then moved on to discovery. Now at this point, the case in Minnesota is not just the RCAF and the feeder case. There's been a whole host of other cases consolidated with it. In just the class front, there's also 3 other classes of beef purchasers whose cases are consolidated with ours for the purpose of discovery. Consolidated is just a fancy word for one judge is managing them together. So there's a direct beef purchasers. That's the class of people who buy beef directly from Tyson and the others. Think Cisco, think US Foods. Then there is a consumer class, folks like us who buy meat from Kroger's or from any other supermarket. And then finally, there's a commercial indirects class, which are the likes of restaurants and other commercial entities that buy food indirectly from the defendants, via people like US Foods. And then more recently, a number of the large beef purchasers have also filed individual actions by themselves. So what that means is it's a very large case. I couldn't count the number of lawyers acting for the various sides, but it's a very big, large, significant piece of litigation. And one of the downsides of that is that it can be sometimes slow to progress. So since the motion to dismiss last year, we have spent a significant amount of time negotiating with the defendants, fighting with the defendants, and arguing before the court about, how broad of the documents that both parties should produce, how many depositions every side is going to have to give, the manner in which the discovery is going to be scheduled, when key motions are going to be due, and by and large, whilst it's been a more tedious process than we would like, we've been very successful. We're getting the discovery that we want. We're getting the case set up in the manner we want, and we're going to get to take the amount of depositions that that we want in the case. We, by way of example of one of those disputes, we said that we should be entitled to about 28 depositions per defendant family. They said 10's about right. The court agreed with us, and we're getting about 25 or 28. So the court thinks it's a serious, significant case, and it's going to treat it as such. We are now starting to get substantial productions of documents from the defendants. So the next little while is going to be spent sort of reviewing those. There'll be some more discovery work and disputes, and then we'll start the sort of witness discovery early next year. So this is sort of an overview of where we're at in terms of the court schedule. So we've got all the initial discovery deadlines to get documents out in December. and the defendants are going to have to be substantially complete, which basically is they have to be almost done, have to give almost all of their documents to us by February. Once we have those, we can start putting defendant employees and former employees in the chair and asking them questions under oath. Likewise, there'll be depositions of our plaintiffs as well. And the next big test in the case is class certification. Our motion for class cert is due in August of next year. What that is basically the motion where we say, Your Honour, this case is suitable for resolution on a class basis as opposed to an individual basis because everybody's claim is sufficiently similar that it's more efficient to deal with it on a class basis as opposed to an individual basis. And there's sort of stringent statutory tests that you have to meet to do that, and it has become a bit of a battleground in antitrust in recent years as defendants and some more judges who are more hostile to class actions have tried to find ways to make it more difficult to bring class actions. So that's going to be a very heavily contested motion. We feel quietly confident about that for a variety of reasons, but that I won't bore you with. But there has been some good precedent already in the broiler chicken case, which is a bit ahead of this case, where the judge did certify a class there and rejected all of the arguments that we expect defendants to make here. So we're sort of quietly hopeful about that. Once we get through class cert, the court's then going to look and to set a trial-ready date and a date for summary judgment. But it's not going to do that until it's got through class cert. So the big picture takeaway is, for the rest of this year and sort of halfway through next year, very much focused on discovery. Second half of the year is focused on class cert and tidy up bits of discovery. And then it'll be summary judgment and working towards a trial in 2020. To get my dates right, 2024. And I should say, this is obviously a slow process. There are certainly times where antitrust cases move faster, but this is, for a large case of this magnitude with this many parties, this is not uncommon, nor is it anything to be concerned about. And we just keep pushing ahead. As I've said before, and every time I've spoken, if you sold fat cattle to the defendants or you traded lamb cattle futures, there's nothing you need to do to join the class. You are automatically in the class, and what will happen is that, assuming a class is certified or if a settlement is reached, you'll receive notice of the fact that we understand you to be a class member, and at that time, you'll have an opportunity to opt out if for some reason you didn't want to be a part of it, or more likely that you want to participate and you'd better provide your documents and your details. So there's nothing you need to do now except to keep a good record of all your fat cattle sales and your live cattle future transactions, so that hopefully in the event that we're successful either with a settlement or a judgment, that you'll be able to participate in that. And then the other thing is always, if you notice anything strange or you saw one of the defendants do something odd, get in touch with Bill and he'll put you in touch with me or a member of the team, and we'd love to speak to you about it. Government investigations. So I know that folk would have seen various politicians call for the USDA or the state AGs or the USDA to give an update on where those investigations are. I do not expect that the DOJ is going to give a public reporting on where it is. What we know and what we can share with you publicly is that all those investigations are ongoing, they're all active, and they are all similar in a discovery phase. All the government entities are still gathering documents, so they haven't made a formal decision to charge or to not charge. They're still in the process of getting discovery. So those continue. You rest assured, if the DOJ or the state AGs decide not to go forward, you'll hear about it in the ag press the very next day, because Tyson will put a press release out saying that it received a no action letter. So until you see a news of Tyson doing that, you know that the investigation is continuing. The other point to sort of flag up for folks is you would have seen the press about the DOJ's troubles with the prosecution of the chicken executives in Colorado. And we often get asked, well, what does that mean for your case? Is it really bad? The short answer is no. It was a criminal case, much higher standard, beyond reasonable doubt. We're obviously in the civil world where it's the balance of probabilities. And the second thing is, it's just really, really hard to prosecute individuals for crimes committed on behalf of the company. Historically, the governments have a much worse record at trying to prosecute individuals. In price fixing claims, they have a much better record of convicting companies. I was not attending the trial, I did not see it all, but the sense I have from those who focused it closely, there's also a sense that the government their reliance on one cooperating witness was probably misplaced, as he was not particularly reliable and was seen to a bit of half-truths, for lack of a better word. So, I wouldn't read too much into what happened there. I don't think it's a really good read across for what's going to happen in our case. We're certainly not treating it as such. I'd note that both Pilgrims, and I think Tyson had already agreed pleas with the feds in that case, which might give you a better sense of how they internally sort of viewed the conduct there. That was the slide I was meant to be on. Other litigation. I'm not going to dwell on this too long. Again, I'm sure most of you are aware, there is, lots of antitrust litigation happening in the ag markets right now. There's, broiler chicken, pork, turkey, peanuts, and there is also more recently suits against John Deere. All of those are proceeding, relatively successfully. The plaintiffs are getting good decisions. There seems to be a growing acceptance and also, I suppose, an educational process going on where the judiciary is being, re-engaging with ag markets and their particular characteristics, which is all very helpful to us. There's even very helpful litigation for us in the poultry sector, not just in terms of the defendants' efforts to fix the price of broiler chickens, but they were also fixing the prices of the wages they were paying to their people working at the slaughterhouses, people working at the hatcheries. Some really damning evidence coming out there of, Tyson and Pilgrims and others' efforts to, not pay their employees, a fair wage. So, in short, these large ag processors who are, putting a bit of a stranglehold on producers are, suffering in general on the litigation front at the moment, and that's I think, helpful and overdue. The John Deere matter is very interesting. I flag it up because I suspect more than some of you will own John Deere tractors. The case there is sort of centers around a movement you might have heard, the right to repair, which is this idea that if you buy the product, you should be able to fix it, or you should be able to take it to a dealer of your choice to fix it. As some of you may know, with some of the more recent Deeres, you can only get them fixed through an authorized dealer who has the relevant codes to check the errors. So the suit is alleging that that is basically a monopoly of the service market for John Deere's. There's a motion to dismiss pending, but if that goes through, it's really a really interesting one to watch because it's kind of stretching the antitrust laws, and there are lots of other equipment manufacturers who would be, a bit concerned about that if that goes through. So that's certainly one to watch, and I'll keep Bill apprised as where that's going in case there's an opportunity for folks to participate in that. That was my rush through of where we are. I've wanted to leave some time for some questions, as did Bill and Jade, so I'll open it up to questions, and I will apologize, it's a bit hard to see if people have questions. So.
Okay, I've been told we've got time for a couple of 3 questions, so. Patrick, before we begin, can you just give a rough summary of the allegations we have made in this complaint? What is the basis of our complaint against the four largest backers?
That's fair enough. I assume, like everyone else, we've all spent 4 years thinking about it. The gist of the complaint is this. You will recall, no doubt, with some fondness, the manner in which cattle prices fell through the floor in 2015. So our suit starts in January of 2015. Recall that cattle prices were rising throughout 14 to sort of historic highs off the back of the fact that cattle supplies were very low. You know, coming out of the drought that we all experienced at the beginning of 2010 through 13, there just wasn't a lot of cattle around because people had liquidated their herds. So coming into 15, defendants' margins are not good. You know, the beef prices are still stubbornly high. There's still not a lot of cattle. They're having to compete for them. And what we say is they decided they had enough of this. They had, they didn't like not running for margins. So they all got together and agreed to stop buying as much cattle. And they stopped buying as much cattle, particularly in the cash market. That caused everyone to have to feed their cattle to heavier weights. Feedlots got, despite the fact that there was not very much cattle around, were not current, and it caused this dramatic price collapse. And then thereafter, we say the defendants sort of, managed the allegations. They managed their slaughter volumes in sort of parallel to ensure that their collective demand did not outstrip, the cattle that was available. We base these allegations on a couple of things. The first is sort of, expert analysis of the economic evidence available, so the USDA's records of, prices and slaughter volumes, some other industry statistics of that nature. We also plead the testimony of a former JBS Swift employee who was told by the fabrication manager down at the Cactus plant that the defendants had an agreement to cut back the kill when prices got too high. And we plead other evidence of the defendants acting in parallel in the manner in which they bought cash cattle. So that is the gist of the allegations, is that sort of the coordination of the manner in which defendants bought cattle caused the prices to fall in 2015 and then remain low thereafter. And what the beef plaintiffs say, so the people who bring beef purchasing suits, they say is, well, because the defendants were reducing their slaughter volumes and because they were the main choke point through which all cattle and therefore beef must pass, there was less beef coming to the market, and that has meant that beef prices have been higher than they ought to have been. So that's the gist of the cases moving before the courts in Minnesota.
Yeah, John Hanson from Wyoming.
Hi, John.
Hopefully, when all this is resolved and we win, which I hope we do, I see where the futures people will be compensated and the feeders will be compensated, but it looks to me like the people from the very bottom end, the cow-calf people, and are we left out, or do we have an avenue for compensation?
So the suit brought is on behalf of at the feeding level, the cattle feeders, and the reason for that is the structure of federal antitrust laws. So under federal antitrust laws, you either need to be a direct seller or a direct purchaser to bring an action under the Sherman Act for damages. So that's where we thought we could bring the most impact in terms of having a suit that would challenge the conduct. There are certain state laws in some states that allow people more diffuse in the chain to bring claims, but that is not it's not a nationwide right. Under federal law, only people with a direct relationship with the defendant can bring a suit for antitrust damages. But what I would say and what I hope is that the lawsuit, like all lawsuits, are not a panacea to everything. It's only one part of what I suspect you all agree is, the wider push that needs to be made to get these markets functioning in a way that we would like. One of the things that we hope, and I know Bill thinks this too, the lawsuit will do is sort of bring more attention to those in the Capitol, in the state legislators, of the problems you're all facing, and it's going to spur action. So if we can sort of bring a little sunlight onto these practices and back up the allegations we've made, I think that's going to inure to the market's benefit in the long run. Typically, after you have these successful antitrust prosecutions, be it a government investigation or sort of civilly, you can see the market be cleaned up for a time, at least.
Patrick, Herman Schumacher here. Would the plaintiffs be part of some of them Packer-aligned feed yards? I mean, would they be part of getting some of these damages?
So the classes played at the moment, and it's subject to change, is that anybody who was on a sort of a cost plus deal is not within the class. The class is basically defined as those who were trading on a cash basis, on a negotiated basis, or on some type of agreement that was sort of directly impacted by it. So if you were trading on just a formula deal that, say, incorporated, the 5-area average steer price for the week, or the Kansas price, you would be included. But if you're on some type of the cost plus agreements that some of the larger feedlots that have special deals with the packers, you're not in the class, because regardless of what the cash price is doing, it's not affecting what you're getting paid.
Bill, we've got time for one more.
Right here.
Yeah.
Good to have you here, Patrick. This kind of follows up with John Hanson, and you're a lawyer, not a politician, but could this give impetus, if we win, to the politicians to either break up the Packers or stop the captive? I mean, do you think this could be used politically for cow-calf producers? And because politicians don't have the onions right now to do anything. Could this be an impetus?
Look, I certainly hope so, and I think anyone trying to predict what Congress will or will not do would, rue to regret their words. And I trust this is being recorded. But I certainly hope so. I think what you see, stepping back, as somewhat of an outsider, this is one thing that me and my colleagues find remarkable about the cattle industry, which is, of all the issues in Washington and state houses at the moment, it is one of the few that has, a sort of bipartisan consensus that it's a problem and there should be solutions. Now, there are differences amongst Republicans, there are differences amongst the Democrats about, what those solutions are, and oddly, efforts to impose some reform have been blocked by some members of both parties and pushed by both members of both parties. And I think that so long as those sort of arguing against reform can maintain a plausible deniability that what the Packers have been doing is, just above board business conduct, and it's nothing untoward. It's easier for them to accept the contributions that they're getting and look the other way. I think if you start seeing some good hard evidence that they were actually actively colluding against producers, I think that makes it a lot hard to resist the type of reform that some of the folk on both sides of the aisle have been pushing. So my hope is that, again, it's that sunshine. It makes it harder for someone to stand up and say, no, we shouldn't, intervene and reform the markets because it's working how it should do. So that's where I see the impetus being. It sort of gives that extra bow in the quiver of those who are pushing for that reform. But I just encourage everyone to keep calling their representatives and making the case. I know, the USDA rulemaking at the moment is coming under renewed fire from certain folks. The senator from Arkansas was at it again the other day based on the West Virginia and EPA Supreme Court decision. So, I just continue to encourage Bill does to encourage folks to engage with their elected officials to remind them that you're here and you remain concerned and that it's not going to go away.
Last one.
Okay, I'm over here by Bill.
Good deal.
So I guess my question is we've got DOJ investigations, FTC looking to change policy, USDA, Packers and Stockyards. A lot of government agencies are looking around for antitrust and meat packer monopoly and a variety of our issues. And yourself as a lawyer, and maybe Dave Domina going back to the Pickett case, are you in touch with DOJ, FTC? Are they asking you for guidance or research, or are you in touch with different government agencies on other stuff not related to this case you're talking about?
This is an area I'll have to kind of speak in generalities because there's sort of a confidential issues that we can't go into. But in short, yes, there are lines of communications amongst, for lack of a better word, people in the plaintiff's bar who are prosecuting antitrust cases and the regulators who are also looking at them. It's not just, not just in this sort of industry, but historically as well. That's something that's gone on for a long time. Typically, it's as you might imagine, it's a one-way street. You can provide them with information. They will not typically, tell you what they're doing. But yes, there are often on cases opportunities to assist the government if you think it's helpful.
There it comes. Thank you, Patrick. We appreciate it.
Good deal. Well, I appreciate you all listening to me, and as I say to Bill and Chuck and Eric and Rick, it is a real pleasure to work on this case and try to help you all out. And you don't say this about all your clients, but you really feel that we're on the right side of this argument. So it's a real pleasure to work on a case like that, and we're working as hard as we can to get the result that we all want. So I appreciate the opportunity.